The first question I have, and what I'd like to provoke here is, as attorneys, what changes would you like to see in statute that would help you and give you the proper tools to advocate for 50-50 shared parenting?
All right, thank you, Jeremy. To answer your question, there has to be a strong, solid, and relatively airtight presumption that 50-50 or something close to it is in the best interest of the children. That takes away a lot of the guesswork, because it is guesswork, from judges and lawyers alike as to what actually is in the children's best interest. That term, which has its origins in Nazi Germany, by the way, has been abused to no end. And I've been practicing family law for 14 years, and if you ask attorneys throughout the country, family law attorneys, you'll get 25, all these different answers about what constitutes best interest of the children. When you simply put it out there in the statute, that it's presumptive that 50-50 shared parenting is in the best interest, and then you have a limited number of exceptions that would cause a judge to rule to order some other kind of parenting plan, that's, I would say, a fairly obvious good start. The debate would then be what are going to be the exceptions and how much discretion the judge is going to have to apply those exceptions.
Good morning, everyone. Pleasure to be here again. My name is Jeff Miller. I've practiced for 20 years. I've been family law for about the last 8 or 9 or so. The biggest thing we need is when I'm standing across from a judge and arguing, Judge, my client, say I represent Dad, has a 6-month-old. He's got the nursery. Here's the pictures. Here's the toys he's got. Here's the diapers he's got. And the judge looks and says, yeah, but I just think the child needs, just needs his own bed. Judge, he has his own bed. He has a bed with Mom and a bed with Dad. And Judge is still not going my way. So I start citing, Warshak, Fabricius, and Judge, there's studies that say, and the judge looks at me and says, Mr. Miller, I can find studies that say anything. What I need is a black and white statute in my toolbox that I can whip out and say, Judge, this is the law. Follow it. And if you follow it, this will only take 5 minutes. If you don't, you've at least given me a strong basis for an appeal that after I appeal you 3 or 4 times on the same issue, you're going to start following the presumption. So that's what we need, and that's why this is so important, is I need, as an attorney, and I'm an effective parent as well, so I've been through it, I get it, I know what it's like going through this, but I need something I can grab onto with teeth and say, Judge, this is what you need to do.
My name is Eyal Rosenstock, and I haven't been practicing as long as these veterans here, or as the great Melissa Isaac has. But it's an amazing honor to be sitting at this panel. I thank the Americans for Equal Shared Parenting to give me the honor. What Mr. Miller said is precisely what I want also. I want the statutes to be clear, to instruct and to control the judge. The challenge is, again, Mr. Miller expressed the challenges that judges have their own biases, their own personal biases, and it directly bleeds into every single one of their decisions because there's the vacuum in the legislation, in their statute, and that's wholly inappropriate for any court, but it happens every day in family court. So my fantasy, my wish, and it's becoming more of a reality with this conference, is to turn it into a child protection issue. My feeling is that, and I've expressed it to the panelists, is if we turn it into a father's rights issue, falls on deaf ears. But if it's a child protection issue, people start to listen more carefully. And I'll give you one example, and then I'll pass it to Melissa. I was trying to reach a psychologist to get started a psychological evaluation on alienated children, and the psychologist said, yeah, call me after 4, and I did, and the psychologist wasn't there. Next day, I follow up, again, no response. The next day, again, no response. And I'm starting to get frustrated. So I pulled out the child protection card and I messaged the psychologist and I said, this is an urgent issue on a child protection matter. The doctor called me instantly. Okay, so I feel that if you can present it to the legislatures as a child protection matter, then they're gonna be more attuned to what you're gonna say. And then you have to follow up with the science. I was told when in preparation for this panel is, tell them what to take to their legislatures. You bring to them real PhDs saying real scientifically based things about child protection. That's what I wish that you would do. And I'll put up my PowerPoint presentation on my website so that you can go to real science to take to your legislatures.
Melissa Isaac, I practice in Alabama, in Florida. What we need are standards and accountability. That's what we need within the statutes. Right now, the statute is written, it reads well, but it's not applied very well. So we look at standards. Judges have almost unfettered discretion to interpret the statute the way they please. And the statute is written, I think, intentionally vague, because that's the one thing that the judges want to hold on to is their discretion. So, but we need standards. We have this best interest standard, but what does that mean? That varies from courtroom to courtroom, it varies from judge to judge. And there's something fundamentally unfair that when you are in family court litigation, if you go to an attorney, if a client comes to me, I take the paperwork, the first thing I look at is who's your judge and who's opposing counsel, because that's going to dictate the direction of your entire case. So there's some judges I look and say, this judge here has openly stated he will not do 50-50, but then you might get a judge just down the hall from that judge that is a huge fan of 50-50. That's not law. There's too much discretion there. So we need some standards. If we're going to say, we are going to make decisions about your child based on this best interest standard, at least let the parents know what that means. Let us as lawyers know, what does that mean? Because it dictates the way that we create our case. And then accountability. Parents should be given an explanation. This is why I'm ruling against you. You can go to court. You know, we've had trials that lasted days, and you get a 2-page order. Custody to mom, dad pay child support. Or custody to dad, mom pay child support. But there's nothing in there as to why the judge ruled that way. So I think it would be very helpful for us as attorneys and for you as parents if there were standards and accountability.
And in Missouri, at least, there is a statute that says you have to ask the court before evidence begins to enter facts, findings, and conclusions of law, but you have to request it, and you want to for just those reasons. Because just to follow up on what Melissa was saying, in Alabama, same thing in Missouri. I have 2 clients come to me. One client says, you know, Jeff, how come, you know, your other client got 50-50 and I only got, you know, one night and every other weekend? And the only answer is, it's because you live in St. Louis and you live across the river in St. Charles, 20 minutes away. It's the only reason. One judge was 50-50, the other 20 minutes away across the river in a different county wasn't. So that's why these statutes are important. And one big argument we've had in the Capitol is consistency. We have to have consistency, and that's what this statute does. So never mind across the river, across the hall, you don't have these same things happening. That's exactly right.
One thing I'd like to add about the discussion about judicial discretion, and I totally agree with what Melissa said, that judges in family law with custody decisions have way too much discretion. One of the arguments you'll hear from bar associations against 50-50 presumptions is that, oh no, we can't take away our precious judicial discretion, like if that's some kind of like constitutional bedrock or something. In criminal law and in civil law, judges have a lot less discretion. I practice in these areas. I've been an attorney since 1999 in Central Florida. I can tell you from my experience that in family law, judges have much more discretion than in other areas of law. Tightening up the statute, which for the best interest of children, as we've all seen from the social studies that have been going on for 2 decades now, would be a presumption of 50-50. Applying the exceptions when necessary still would require some judicial discretion. So yes, you would still need us family law attorneys for something, but it would make the law more predictable, and that's what the family law system is lacking right now, is predictability and consistency.